Justice Breyer, to begin on a somewhat personal note, what would you like to say to Judge Weinstein and those who've assembled at DePaul to celebrate his career and assess his impact on civil justice?
Well, Judge Weinstein, I'm glad you're here. I'm sorry I'm not there, but I'm glad that all these others are here, and it looked like a terrific program, and this certainly is the right thing to do, to celebrate Judge Weinstein's career, because as you point out, he is a model, and it's celebrating justice, not just him. And it's our justice system, not just him. But it's the way he does it that counts.
Judge Weinstein's been a vigorous and proactive trial judge. How do you think appellate judges should approach the decisions of such trial court decision makers? Is there some deference that the appellate judges ought to show?
Yes. They should approach it with appropriate caution. They should take into account the fact that the trial judge is likely much more familiar with the case than they are. And so be careful when you're on the Court of Appeals to stick to what you know, and you defer to the lower court because you think they know more about what's going on, which is true.
Do you ever feel any regret that you have never been a trial judge, never had that experience?
Well, I've never run a 4-minute mile. There's a lot of experience I don't have, and I don't know I do. I mean, my brother, who's a trial judge in San Francisco, makes very clear that the profession has different parts. Now, he also makes clear where he thinks the cream of the profession lies, and I think it's not, in his opinion, in the appellate courts. He loves being a trial judge, and I'm sure I would have liked it.
Judge Weinstein's been an innovator in dealing with the challenges of mass claims. What is your sense of the value of judicial innovation in dealing with such challenges?
It's valuable. I mean, I explain very often to the ones I most like to talk to are my granddaughter's class. She's in the 5th grade, and they understood it perfectly well, that people, being human, get into arguments. And most of them, they understood this perfectly well last week in their 5th grade class. We get into arguments with our families, with our brothers, with our sisters. With others, the arguments might be about family, they might be about money, they might be about crime. But really, most of the time, we get over it, and we work out ways to settle it. And when it isn't settled, then it's a failure, and then we go to a lawyer. And the lawyers try to work it out. And sometimes they fail, and then we go to judges. But ultimately, the judge is trying to work out, and the trial judge sees this all the time, he's trying to work out a problem. And there are many different ways of doing it, and experimenting along different lines to see which will prove a satisfactory solution, which includes the justice of the situation and not simply settling the argument. But there are many different ways of doing that, and of course innovation has a proper role. Someone once told me the wonderful thing about law is nobody's ever done anything for the first time. That isn't quite true. You do have to have some experimentation to see what works.
In light of your views in your marvelous book, Breaking the Vicious Circle, how should we balance society's reliance on courts, especially in these mass situations, and on administrative agencies?
Well, administrative agencies and courts do different things. Administrative agencies they still are rather expert, and they are trying to administer detailed law, for example, environmental law, in areas where knowledge really counts, specialized knowledge. They have to be able to adjudicate, they have to be able to make rules, but they're in a particular area that requires specialized knowledge. The judge, for the most part, is a generalist, and that's how it should be. Because if we only had administrative agencies, our law would fly apart in 50 different directions. Every agency thinks what it's doing is the single most important thing in the world. And they sometimes steamroller people who get in the way. And then that's one reason why we have judges review this, to see if they've been reasonable. And that's why you want a generalist judge who is seeing that what the independent agency or the agencies are doing makes sense, it's reasonable, and it isn't unfair to individuals.
Judge Weinstein has been inclined to the vigorous use of juries, even advisory ones. What's your sense of the role of the jury in our system and even advisory juries?
Well, here, I'm not an expert. It's really, you'd have to ask my brother or Judge Weinstein. But from listening to the trial judges who use them, juries don't always work. A matter can be too specialized and they don't always understand it. We've had a few patent cases where I know many judges who try to avoid jury trials in such cases. In fact, they try to avoid trials in such cases. But they're pretty, by and large, positive about the common sense role of the jury. As you will get, they say, a view of what the community thinks. And that's important in a country where what the community thinks is what is meant to control the rules, the laws, the ultimate product of the democratic legislative institutions that have been set up.
Many judges appear quite concerned about reversal. Judge Weinstein has not manifested that deep concern. How do you think the judges at the trial level should think about the prospect of their decisions being reversed?
That's not their problem. I mean, I often, too, explain why we only take a handful of cases. If all the judges are of one opinion, we'll probably not take a case. And part of the reason for that is we know perfectly well that the judges are not in higher or lower courts. They are in different courts. And they have their experience and they're trying to solve a problem. And if there's no more reason, really, that we have the last word, but that doesn't make it the most right word. And so don't worry about it. You get reversed, so what? So 10 or 8 or 4 or 2, depending on what court you're going to and so forth, have a different opinion of the matter. That's their right. Would you like a story about that?
Yes.
The most applicable thing that I can remember seeing once on television. I saw, who was the great piano player?
Horowitz?
Yes, Horowitz, Vladimir Horowitz. And he was teaching a master class, and some of these young students went up to him and bravely asked him a few questions. And what's your favorite concert hall? He said, I think Cleveland maybe, or maybe Vienna. He says, not Carnegie Hall? No. He said, that's surprising you'd have that opinion. He said, well, let me tell you about opinions. He says, I was with Charles Munch, who was guest conducting in San Francisco, and a society lady came up in the intermission. Munch said, how did you like the conference? And the society lady said, I liked it, but not Haydn. I've never liked Haydn. And Munch said, that's all right. He said, Haydn doesn't mind. You see, he said to Horowitz, he says, you see, that was her opinion. Now, she's entitled to her opinion. That is, I think, what the judges should think when they're reversed. That's their opinion. They may be right, they may not be right. You have to follow it. But it doesn't mean that it's necessarily right. It just means that people have a different view on the case, and you will follow it if you're a trial judge in the future.
Judge Weinstein was appointed by President Johnson in 1967. He's been on the bench a good long time. And I'm wondering what you think the extra value may be of judges who've had a good lot of experience. You yourself have now been on the court quite a long time.
Yes, of course. Biased in this respect, but I think one of the reasons, I mean, I wouldn't be sorry if there were a limited term as long as it was very long, because you don't want a judge calculating what his next job is going to be while he's trying to hold the present. That would be a mistake. But I do think you learn over time. I think you do see, but particularly in appellate courts, you do get experience in a field. You do get to understand the field a little bit better, and you get more emotionally used to the job. You have a way of going through problems, and you do your best. It doesn't mean you don't do your best, but I think it becomes a bit easier, and you have a bit more to contribute, as in any other field, over time.
You were a distinguished academic, and of course I know because I was one of your students.
Great student.
Judge Weinstein, too, has had a fruitful association with the Academy. What extra does that kind of experience and association add to a judge's abilities, do you think?
Some. I mean, different experience adds different kinds of extras. A trial judge, for example, has experience that I don't have. An academic is a person who is more used to looking at cases and seeing how they fit together, because a lot of the job is that. When you're teaching or when you're writing, you're taking a whole group of cases that the courts may not have time to see as a whole. And you're seeing how this fits over there and that fits over there. And I think that's one helpful kind of experience. It's not necessary that everybody have it, but it is one helpful thing that some judges can have.
There's been a sense, I think, recently of a sort of schism between the academy and the practice of law, or perhaps the courts. What's your sense or reaction with respect to that feeling of separation?
Well, when I was a teacher and when I was a student, certainly, we tended to think of the profession as having three parts. The judiciary, the judges would decide the cases and they wrote down their reasons. So you have not just will, you have an explanation, a reasoned explanation of why you decide this way rather than that way. The academics, as I said, have time to do something judges don't necessarily always do. And that is look at a whole field or groups of cases and to suggest why the whole group or what parts of it make more sense and make less sense. And then the lawyers read that, or at least where it's useful to their case, and they will transmit it back to the judges. And so the judges will write new opinions. We hope learning from some of the things that the academics have suggested as transmitted by the lawyers. And all three form part of a profession that can, in many ways, improve through that process. Now, I fear maybe today there are too few academics who might be willing to do that. And if they don't do it enough, and if they don't write simply enough, the lawyers won't read it. And if the lawyers don't read it, they're not going to tell the judges about it. I mean, maybe sometime the judges will read it directly, but it has to be very relevant before they will. So the treatise writers, the lawyers who read the treatises, the judges who can read the treatises and listen to the lawyers, and then produce new opinions which are in turn subject matter, all are part of a whole profession which looks towards a law that works, we hope, better.
A longtime contributor to our symposium, Mark Galanter, has written quite persuasively about the Vanishing Trial. And I'm wondering what your reaction is to what seems to be a pretty clear trend, the disappearance of the trial as a regular phenomenon in our courts.
I have two opposite reactions. To some degree, insofar as people can get their problems settled less expensively, say in arbitration or mediation, without the complexity and the cost of a trial, so much the better. But even if that's so, the disappearance of trials may reflect, on the civil side, a decision by business not to go to trial, in which case, although they might get their problems settled, there will be less of a way of subjecting the rules under which the problems are settled to the crucible of a judge trying to see if they're fair and the better rules, and you'll miss something there. And I think what is more unfortunate is if you look at the figures, you see 95% of all criminal defendants avoiding trial and going to sentencing. Well, that may be just a fact, but if it reflects too much of a role by the prosecutor to offer plea bargains which cannot be turned down. You either plead guilty to a minor offense or I charge you with a life sentence offense. Well, that is not a good thing. And I've said that why don't we take something from the Europeans here? They have schools where they train prosecutors to be judges. I mean, to look more, I'm not saying they don't here, they do, but to look more towards trying to work out what is the right result in the case, not just whether you win. Now, my brother, who was a prosecutor, said, well, that's what I do anyway. So I said, well, why did you tell me whenever you were on the prosecution side, you never prosecuted a person who wasn't guilty? And then when you went on the defense side, you kept saying you have some clients who aren't guilty. So he said, well, we had better prosecutors then. But you see, you see the problem.
I do.
And I think it's a serious problem, and I think that the lack of a trial is a reflection. And I think we should try to work something out, whether it's training or anyway, there are many suggestions floating around.
As a final question, should we think of Judge Weinstein as a role model? And if so, in what respects?
Yes, he's a role model. He's a role model as a teacher. Look at his evidence. Weinstein on evidence. You want to know what it is? Read the book. He's a role model as a judge. I mean, we have area after area, which you will discuss today, tomorrow, and you will see how he has made contributions in field after field as a judge. And those contributions include seeing both the human side, but not just, everyone has a heart, we hope, but not everyone can combine the heart and the head. And he's been able to do that in case after case, and that makes better law. And then he's a role model as a person. I knew that when Ken Feinberg told me that he took some money sometimes out of his own pocket, and a lot of these frequent filers, you know, have a mental problem. He says, I'm going to pay to have them get some treatment. Well, very good. Okay, so as a teacher, as a judge, and as a human being, I think he's a pretty good role model, which is why you're having this conference, and I'm glad you are.
I'd like to thank you so much for your time and your input. It's really very valuable. So,
thank you.